Well, welcome everybody. We appreciate you joining our meeting today. This is a timely topic. We are thrilled to have with us Kathleen Weron with Ogletree Deakins. Ogletree is a member of BioUtah, and we've worked with Kathleen on several issues in the past. She's been a panelist for us. She's probably arguably the best employment law attorney in the Valley, right, Kathleen? Is that fair to say?
Thanks, Kelvin.
But we're really thrilled to have her on to talk about this topic today. Many of our companies have indicated an interest in this because we have a lot of our companies, especially on the manufacturing floors, employ a very broad ethnicity of employees. We had one company recently, because of the Supreme Court decision, lose almost 20% of their workforce in one fell swoop. It's been pretty devastating. So we thought it would be appropriate to have Kathleen take a few minutes, give us an update on things, and give us some guidance. So Kathleen, I'm going to turn the time over to you and listen in.
All right. Well, thank you. And thank you to BioUtah and everyone participating today. I agree with Kelvin. This is a very hot topic that we are seeing headlines about on a daily basis. And there's a lot of discussion. What I thought would be useful was just give you an overview of where I think the concentration of the Immigration and Customs Enforcement actions are, and what to expect if you do have ICE show up at your workplace, and educate you a little bit on the different types of warrants that they can show up with and the different kinds of actions. So I'm going to try and cover that all in the next 55 minutes, but I do want to encourage questions, and you're welcome to ask them as we go, or we can get to the end and ask questions, and hopefully I can answer them for you. So I'm going to just start with a little bit about what we know about the new administration and their immigration actions. Initially, when Trump administration took over in January, we certainly heard confirmation that there would be increased enforcement actions within the first several weeks of the administration, which has proven to be very true. These enforcement actions may be taken against individuals in the United States without proper documentation and individuals with final orders of removal. So that was January. The other thing that we learned about this new administration is that the Department of Homeland Security expanded the locations at which enforcement actions may occur. So ICE officers are now authorized to conduct enforcement actions in the workplace and in previously designated sensitive areas. So this is a change from the Biden administration to the Trump administration. And designated sensitive areas used to, under the Biden administration, include schools, medical facilities, places of worship, social establishment, children's gathering places, places for disaster or emergency response and relief, wedding or funeral sites, or public demonstrations, parades, marches, rallies, etc. The Department of Homeland Security expanded ICE enforcement actions to these locations. These are no longer considered designated sensitive areas. So you can have ICE enforcement actions during these events and at these places. Some wise things that employers should be doing now, if you already have not, and that's to make sure that you have a very robust I-9 process. Now is a good time to do your own internal audit. The Immigration Reform and Control Act requires employers to verify all candidates' identity and employment eligibility. We typically deal with this on the Form I-9. And every employee needs to have a Form I-9, and that form is available. It's pretty straightforward. The directions on what identification is required, which we'll go through briefly, is on that form. So you'll want to make sure that you have the most current form and that you have a robust I-9 practice. So two important implications for the I-9 practice, and we'll go through that. First, you cannot overlook discrepancies between a job candidate's I-9 disclosures and immigration documents. You must review job candidates' I-9 forms. And if the information on an I-9 is inconsistent with the information contained on the applicant's immigration documents, you cannot assume it's a mistake. Instead, you have to investigate, make an informed decision regarding the immigration status. Secondly, you cannot accept questionable immigration documents. If the job applicant's documents appear to be forged or altered, then this requires additional scrutiny by the employer. So the I-9 form, like I said, is a U.S. form. It's available online. The employees must complete and sign the form no later than the first day of employment, but not before accepting a job offer. So there's some tension there. Also, employers or their authorized representative must complete and sign the form I-9 within 3 business days after the employee's first day of employment. So there are some deadlines here, wise to make sure that you're complying with those. And then finally, that the employer must physically examine the documents consistent with the procedure authorized by the Secretary of the Department of Homeland Security. And a note here, we're going to go over this pretty fast because I think we have a lot to cover, but the Department of Homeland Security has a very good website, has the most recent forms, and a good FAQ. So I would encourage you to check that out and make sure that you're using the most recent forms and you're following the most stringent practice. So acceptable documents, again, I've included on this slide the back of the I-9 form. The information is pretty complete, so we won't spend a whole lot of time here, but it provides, you could have one item from list A, that's sort of the one and done item, or one of the items from list B and from list C. So take a look at that, make sure that you have the examined those documents that are listed here on the back of the I-9 form. And then, of course, there's always tension for anybody who is trying to comply with the law. Generally, employers are required to accept facially valid documents without further inquiry. So if you get the proper documents, you cannot inquire further, you cannot ask further questions because this could implicate discrimination concerns. But at the same time, under this new administration, you need to have a robust practice so that if you suspect some of these documents are forged, and for example, there's a typo, the name is misspelled, the driver's license picture doesn't look like the individual, those kinds of noted obvious discrepancies, then you do have a duty to investigate further. But you can't simply, if the documents appear valid, then you have to stop, copy them, put them in the file, and move on. If they are obviously forged, there's misspellings, or like I said, the picture doesn't match up, then you do have a duty to investigate further. So a word of caution here, you're not a document expert, you're not a forgery expert, and you're not required to be. What you want to use is common sense. Use your best judgment. If something looks like it's been whited out and typed over with an old-fashioned typewriter, then that's going to be something that should raise a red flag for you. But the standard is that they reasonably appear to be genuine, free of typos, free of obvious alterations or cut and paste. And then check the document's expiration date as well. Expired documents would raise a red flag. One way to resolve this issue in trying to balance discrimination claims versus your duty to investigate further is to sign up for E-Verify. E-Verify is voluntary in the federal system. Utah requires E-Verify for employers. However, there are no penalties if you don't E-Verify. So it's a little bit of a dog without a bite. However, I would suggest in the current climate, signing up for E-Verify and using E-Verify to take that burden off whoever is in, whether it's HR or whoever is in that first line of trying to determine whether or not a document can be used for I-9 forms. One way to just circumvent that whole tension between discrimination claims and making sure that you're using common sense to determine whether a document reasonably appears to be valid is simply to sign up for E-Verify. Both the federal government and Utah have a very easy website, and I would refer you to that website. So what I would recommend in this current environment as sort of a first line is to make sure you do an I-9 audit and go through your employee personnel files, whether they're electronic or in hard copies, and identify whether you're missing any I-9s. Make sure that any gaps are resolved. Ensure you've retained and completed Form I-9s for all active employees. Keep those separate from their personnel files in a separate confidential file, and then be sure to retain the I-9s for the mandatory period, which is 3 years after the hire date or 1 year after the date employment ends. During COVID, there was a period of time where employers could remotely check identification of documents and remotely do the I-9 process with an employee. That's been rescinded. Hopefully everybody on this call knows that, but you should not be doing any remote I-9 practices, but rather doing the document review in person. Now is also a good time to check your files, audit your files. If you've had anybody who onboarded during that moratorium and were allowed to do the remote I-9 verification, now is a good time to go back and if there's a gap there, make sure that you have conducted an in-person review of documents so that their I-9 file for every active employee is up to date. If you have staffing companies, PEOs, vendors, etc., make sure you review the language and ensure that reasonable representations and warranties are in place on the I-9. Staffing agencies should consider and adopt best practices and be fully compliant with I-9 laws and other relevant immigration laws. If you have independent contractors or use vendors who provide contractors, make sure they have contract language, ensuring that they are providing contractors legally authorized to work in the United States. So also a good time to review any contracts you have with PEOs or contractors or vendors to make sure that you don't have any gaps there in I-9 compliance. All right, so let's talk about the different kinds of enforcement actions, which is really the highlight of this entire presentation. I just wanted to give a little background on the I-9 process because I do think it's wise at this point in your employment practice to make sure that you've done your own internal audit and you're complying with I-9. Have complete files for each employee. that is active with you, or a contractor, or even a staffing employee, that you've taken reasonable steps to ensure that you're I-9 compliant. So there are 3 different kinds of visits that you can receive from the Immigrations and Customs Enforcement. We'll just call it ICE. The first one is a visa sponsorship verification. This is very routine, very normal, doesn't get a lot of press, and is really a visit to ensure compliance with employer-sponsored visa programs. So employers who have sponsored certain visa types may receive a unannounced visit from ICE, and that does not require a warrant or subpoena. They are there basically ensure compliance with the employer-sponsored visa program. So they will ask questions perhaps about what the employee is doing, what the job duties are, what the title of the individual is, and it's a short visit just to ensure compliance. Another is the Form I-9 audit, which is why I started this presentation with take some time now to go through your own internal audit, because if you do receive a visit from an immigration agent that wants to do an I-9 audit, you'll be ready for them, and you will have any gaps that you may have during your internal audit identified, you have remedied, and so you're ready to comply with a request for an I-9 audit. And typically what happens in this situation is an immigration agent will visit and request the employer produce Form I-9s and supporting documents. So those documents we talked about, you've got the Form I-9, and then you have the 2 pieces of identification or documents copied. It's in a separate confidential file for each active employee. This will typically come with a subpoena or a request for documents, and will be served on you by an agent. They are not permitted at this point to ask questions or search the premises, and they must basically leave after they've delivered the subpoena. So somebody shows up, they deliver a subpoena, it has deadlines in it, which we'll talk about in a second, and then they leave. So the next kind of visit that you might get, and this is the one that gets all of the press attention and probably the one you're interested in today, is when an ICE agent shows up with a warrant. And they may present an arrest warrant or a search warrant. An arrest warrant may be for an individual or a group of individuals. A search warrant is to search the premises. A judicial warrant is signed by the judge. And this is the only type of document that allows government agents to enter private areas of the business, and that must be specifically described. So if you have a judicial warrant, it will describe what areas can be searched. If it's a manufacturing plant, they may say the manufacturing floor or, employee cubicles, but it will describe the when, where, how, and what more specifically in the judicial warrant. We'll talk about that in a little bit, and we'll also differentiate a judicial warrant from an administrative warrant. But I'm just giving you a little bit of an overview. So ICE agents may arrive at a work site without prior notice as part of an investigation. They are not police officers, but their uniforms may display police or federal agent. They may be armed. Occasionally, local police officers may accompany ICE agents during these actions, and they may visit your business to locate, again, a specific individual, a group of individuals, and during their visit, they may attempt to question, detain, or arrest other individuals present. So obviously, of the 3 that we just discussed, the typical visa investigation is probably meeting with HR or perhaps some people in operations about whether or not the employer is complying with the visa. It's an interview, and usually one or two ICE officers may show up. Then the second is an I-9 audit, and that's really serving you with a subpoena. You have 3 days to respond to that subpoena. So they'll serve you with the subpoena and then they'll leave. You have 3 days to comply. Usually they won't give you an extension. It is 3 days, but if you've done the I-9 audit internally, you'll be ready for it. And then the third one is where ICE shows up to arrest individuals either with an administrative warrant or a judicial warrant. And this is going to be the one that is most disruptive to your workplace and the one that we'll spend the rest of this hour talking about how to prepare for. So the first thing that you should have is a response plan. So a response plan, you think through how ICE agents might enter your facility. If you're a manufacturing facility, is there somebody at the front desk? If you're an office, do you have a receptionist? Who will be the first person that ICE might encounter if they come to your workplace? That is a person who needs to know what the response plan is, and they need to know what to do in that situation. Usually the best thing to do is make sure that that person knows who the key points of contact are in the event that ICE shows up with a warrant or either a judicial warrant or administrative warrant, and they understand the difference between both of those and then who their points of contact are. And I would recommend, if you have a legal team, somebody on the legal team or the management team. And these individuals should be responsible for coordinating the response to any government request and or search warrant. So whoever that first line is in your facility or in your office, and you may have office functions and manufacturing functions, think through who that first point of contact would be. That person needs to have the name and phone number of the company's counsel and or management team so they know immediately to alert them. And then once those individuals are alerted, then they can help respond to the subpoena, or excuse me, the warrant. You can request identification and contact information of the government agent and calmly ask the agent to wait while the appropriate contacts are notified. This should be part of your plan. Immediately reach out to company designated points of contact. And obviously, this is you preparing that person in the point of contact position, but they may or may not wait, depending on what kind of a warrant they have. So that first point of contact needs to confirm whether the government agents have a search warrant. And if the agent does not have a search warrant, then their access should be limited to a reception area or an adjacent conference room. So if ICE shows up, the first thing your point of contact is going to want to do is ask for a warrant, ask them to wait, and notify members of management. Importantly, if they do not have a warrant, they should not be given access to inspect the facility or work site, nor allowed to interview any employees until after a discussion between the agent and the company management. So again, the agent will serve the search warrant on the receptionist or that first point of contact when they come through the doors. Your company can accept the warrant, but not consent to the search. So if you do consent to the search, and this is why it's important to train that first level of contact. If ICE shows up and they don't have a warrant, but that person says, come on in and go ahead and access private areas and allow that, then they don't need a warrant anymore because you've consented to the search. So you want to be sure that you don't consent to the search. Whether you're the first point of contact or you're on that management team of key contacts of people responding to ICE agents, you're going to want to ask for the warrant before you consent to a search. They don't have access to your facility without a warrant unless you consent. So, I've modeled a little bit of language here because this is, like I said, this can be disruptive. The agents can be armed. There can be several, a few, half a dozen to 500 officers showing up at your facility. So whoever that first point of contact is, the first thing they need to say is, I can't give you permission to enter if they do not have a warrant. So ask for the warrant. If they do not have a warrant, this individual should identify that they do not have permission to allow them to enter. Again, invite them to a waiting room, or leave them in the reception area until you can get management down to speak with the agent. Important distinction between private and public areas. So private areas in your facility are doors that are locked. Those are private areas. Unless you have a judicial warrant, you can't enter those private areas. If you don't have locked doors, you may want to consider putting private signs on, depending again on what your facility looks like. If you come in and there's a lobby or a reception area that's unlocked, that's going to be considered a public area, and ICE enforcement agents can be there. However, locked doors or areas marked private are not accessible unless they have a search warrant or you consent. So consider areas in your facility that, are going to be public, such as the reception or lobby area, conference rooms that are accessible right off the reception lobby area, dining areas, parking lots, waiting areas. Those can be accessed by anyone without permission because they're considered public. If you have private spaces and they don't lock, you can consider putting privacy notices up that just say private signs. Either, conference rooms, areas that you don't necessarily have locked, but you do consider private. And if somebody were to just walk off the street, not even an ICE agent, but just anybody would walk in that area, that would be violative of your private spaces. Make sure that those are clearly marked. And like I said, public areas are certainly going to be your lobbies, your waiting areas, parking lots, anywhere that the public can access. So ICE agents can only enter private areas that are clearly locked or clearly marked with a judicial warrant. So without a judicial warrant, they're going to need your permission to enter private areas of your business. So let's talk a little bit about the two different warrants we've seen in ICE enforcement actions. There's the judicial warrant and the administrative warrant. A judicial warrant has to be signed by a judge, and it must indicate at the top of that warrant either it's a U.S. district court or a state court. If ICE agents attempt to enter a private area, they have to have a judicial warrant. You can prohibit them from entering those areas without a judicial warrant. You're also entitled to ask to see and review the judicial warrant. This is what a federal judicial warrant looks like. So at the top, you'll see it says that it's a United States District Court. This is for the Eastern District of California. It's a search and seizure warrant, and it indicates that the warrant must be executed on this date, 5/9/2011. Usually it'll indicate the times. Sometimes it won't. That depends on the judge. And then, at the bottom, you will see that it was issued on April 11, 2011 at 10 a.m. and you have a judge's signature. Those are the hallmarks. That's what you want to look for in a judicial warrant. An administrative warrant does not permit ICE agents to enter private areas without your permission. A judicial warrant does. So that's why it's important to ask to see the warrant. Administrative warrants are issued by the Department of Homeland Security. So what you'll see is usually a DHS seal, label, or the actual form number, DHS form 1200, warrant for arrest, or form 1205, warrant for removal or deportation. This is a very official looking document, and it is official. But if you're presented with an administrative warrant, you may refuse to comply with the warrant and asks the agents to leave. So an administrative warrant will say U.S. Department of Homeland Security, warrant for arrest of alien. And then you'll see here, it will be signed by an authorized immigration officer, but it is not signed by a judge. There's no court. It's not a United States District Court. It's not a state of Utah court. It's from the Department of Homeland Security. And these are easier, obviously, for DHS because they're internal. Judicial review requires DHS to go to a judge, present probable cause, and then get the judge to sign a judicial warrant. It has an extra level of review. The extra level of review, the judicial warrant, will allow them to search private areas with or without your consent. The administrative warrant will not. So again, going back to how to plan for a possible ICE investigation or enforcement action, that first point of contact should ask for credentials. That's not required. They may not give them, but then they can ask for a warrant and then review it. Immediately decide whether it's a judicial warrant or if it's a Homeland Security warrant. Hopefully at that point, the key contacts for the company are on their way down to negotiate with ICE. If it's a judicial warrant, there is no negotiation. They're going to come in. If it's an administrative warrant, again, that's limited to what you consent to in your private areas. Public areas, they are allowed to be in. Couple of things on the judicial and administrative warrant, again, is to check the specifics that are in the event of a search warrant. You want to make sure that it's being executed on the date and time that is on the judicial warrant. If it's expired, if the judicial warrant was for a day that has already passed, it's not valid. If they're executing it during a time period that's not marked, and again, it may not be marked what time a warrant has to be served. And then sometimes, again, it'll say what areas. And if if they're trying to get into an area that's not on the judicial warrant, then you do not have to allow them into that area. Most of these will probably just be a span of days without all of those specifics. But again, you do want to check and make sure that it's not expired. The office address is listed at the place to be searched. So if you have two facilities and they're at your manufacturing facility and you check and the address is for your office facility, it is not valid. And then sometimes there will be a description of the items to be searched. If it's a search warrant, other times it'll be an arrest warrant for an individual or a group of individuals. Again, if it's an administrative warrant, clearly not signed by a judge, not administered by a court, then you can choose to decline further cooperation. If you're presented with an administrative warrant that names an employee or a group of employees, you are not obligated to disclose whether that employee is present, and you're not required to lead ICE agents to the named employee. So it makes a very big difference for how you respond depending on what the ICE agents are appearing with, either a judicial warrant or an administrative warrant. If they do have a judicial warrant, then you need to remain calm and instruct the other employees to do the same. If the government agent enters private areas, assign employees to follow each agent. You can document what's going on, how many ICE agents are there, what are they doing. You can observe them to ensure that they're complying with the warrant's terms. You can videotape them or record them as well. Do not block or interfere with their activities. And you need to advise employees to do the same. Do not block or interfere ICE agents if they come to your facility, as well as employees or the employer should not alert anyone, should not post it on social media, do nothing to interfere with their actions. And some employers have called news reporters to access the site to bring publicity to the situation. I would recommend not doing that. I think the best thing for you to do in the event of a judicial warrant is to comply and make sure that all of your employees comply, and to remain calm while they execute the warrant. Do not discuss the company's policies or practices or answer questions during the execution of the warrant. Ask if employees may leave. If it seems that they are being detained, you can certainly, inform the agent of any detained employees with known special needs. I would also recommend, in the execution of a judicial warrant, unlock any locked facilities to which the agent requests access. Otherwise, the agent may force lawfully the facility open, again, if they have a judicial warrant. If ICE presents you with an administrative warrant naming an employee, again, you're not obligated to disclose whether that employee is present, and you're not required to lead ICE agents to the named employee. If any property is taken, sometimes the warrant will allow documents, files, and/or computers to be taken. Again, you'll want to make a note of what was taken and/or ask the agent to leave a list of all property taken and the name of the employees arrested. If any workers are arrested, you may ask ICE agents where they're taking them so that you can assist their family and/or lawyer in locating them. And then I would recommend that you prepare a detailed written summary of what has happened immediately after the search has concluded. Another thing that you may want to do during the audit practice, the internal audit practice that you have, not only checking I-9s, but make sure that all of your workers have emergency contacts up to date in case you need to notify them of the arrest and location where the worker was taken. If ICE agents attempt to stop, question, detain, or arrest a worker, your employees do have Fourth Amendment rights to remain silent. They do not need to answer questions about their immigration status, where they were born, or how they entered the United States. They may exercise their right to remain silent and may ask to speak to an attorney. Excuse me, as the employer or the employer representative, provide only the information that ICE requests when they request it, and then advise your representative, we don't have to prove our case. You don't have to defend the work site enforcement action, because anything, obviously, that you say, whether offered verbally or, if you are volunteering information in the form of documents, it can be used against the employer. Of course, you want to cooperate and provide the information that they have a judicial warrant for, but you do not have to volunteer information. at this point. Another point on this, although your employees have the right to remain silent, you want to be careful that you as the employer are not providing them with legal advice. So you can recommend that they contact an immigration attorney, but you do not want to offer them any legal advice during or before this process, and you do not want to obstruct in any way. So I will open it up for some questions.
You have one question in the chat.
Okay.
Selma has asked a question about whether or not on some occasions the facility can have visitors attending or training, conducting quality audits who are not active employees or visitors the facility rather than visiting for above purposes with a valid U.S. visa. Are there any actions that facilities should consider in case of ICE agents visiting the facility and raising questions about people who are not your employees? Salma, if I have not captured that accurately, please unmute and clarify.
No, thanks a lot. That was captured correctly. So Catherine, if you need any clarification or if the question is not clear, I can give further context, but yeah.
So as I understand your question, you have employees or non-employees who are present engaged in various activities on your site.
Yes, we can have this in occasion of employees not from the headquarters, but visiting the headquarters for training or for conducting internal audit, but they're not active employee of the site itself.
Okay, so in that situation, if ICE were to serve a search warrant for those individuals or an arrest warrant for those individuals, and it's a judicial warrant, perhaps they received information that these individuals would be at your site, you need to comply with that judicial warrant, even though they aren't your employees. If it's a warrant signed by a judge that's specific to your site and your address, and it's executed on the day that's listed on the judicial warrant, you will need to comply with that. If it's an administrative warrant and ICE shows up with an administrative warrant for certain individuals who are on site, you do not need to comply with that. You
okay.
must return. And the way that's handled is, this is not a judicial warrant. I would ask for you to return with a judicial warrant, and then we will comply.
Okay, perfect. Thanks a lot.
But if it's a judicial warrant, they may have some intel or information that those individuals are going to be at your facility during a certain period of time, and go to a judge and get that information in front of the judge for a warrant during the place and time, which just happens to be your facility, then yes, you do need to cooperate and comply.
Mm-hmm. Okay, thank you.
There is another question. Are you seeing ICE agents use deceptive practices to search a company's facility, or is it more that they are banking on the ignorance of the company? Typically, the administrative warrant is easier and quicker for Department of Homeland Security to issue. So it's all internal. You don't have to have any evidence. You don't have to prove up probable cause to a judge, and you don't have to wait. So administrative warrants are certainly more common. And from the presentation, you can see that they are official, but they don't carry the same weight as a judicial warrant. So not only are they administratively easier, is ICE banking on employers opening the door when they show up with an administrative warrant? Probably. I don't know that that's their intent, but it's certainly easier internally to get, And if an employer, like I said, if you have an administrative warrant and the employer then consents to a search of the, facility, or, leads them to an individual, then, that there's no, that is valid action. Because once the employer consents to the workplace search or the workplace investigation, then they no longer need a judicial warrant. And we see that with OSHA all the time. If OSHA shows up without a warrant, an employer can say, you can't access the facility. OSHA will often say, fine, we'll go get a warrant, and then they do and execute the warrant. But if OSHA shows up and you consent, then they don't need to get that warrant, and you've waived that right to have a judicial warrant. So it's certainly administratively easier. It's that one step less review required by a court. And I think some employers may just go ahead and consent in the same way they do when OSHA shows up. But employers have Fourth Amendment rights against unlawful search and seizure. So that's why a judicial warrant is required for a search or seizure, unless you consent.
We have a couple more questions we want to get to here, but just a finer point on this. If an ICE agent comes in and they try to be assertive and even misrepresent an administrative warrant, what should they do?
I would recommend getting in touch with legal counsel right away.
Okay.
Because it's intimidating, and I would imagine 1 to 10 armed ICE agents showing up at your site and getting pushy with an administrative warrant and not a judicial warrant is disruptive and intimidating. And I would recommend that, again, that first point of contact, that person who is going to be on the other side of the door when ICE enters, needs to know 2 things. 1, do you have a warrant? And 2, exactly who they need to contact immediately. And ideally, that first point of contact knows whether the difference between a judicial warrant and an administrative warrant. Because if it's a judicial warrant, they may just blow right past her or him. If it's an administrative warrant, that person needs to understand that they can invite them to have a seat until the key management people or in-house counsel or legal counsel arrives. But if it is not a judicial warrant and they insist and they're pushy, then I would recommend getting in touch with legal counsel immediately.
Jim has a good question about controlled environmental areas, if you want to read that one.
Okay, I'll read it out loud. What about controlled environmental areas, clean rooms, or labs where company products could be compromised if a judicial warrant is being exercised by ICE agents and they want to access these types of areas? I would recommend, I've had this question with regard to PPE and safety requirements as well, and I think these are similar questions. You can certainly request it. You can certainly request that the ICE don the PPE or not go into the controlled areas because they are clean rooms or labs where company products could be compromised, and reason with them. But if they have a judicial warrant, you would be unable to stop them if they insist. And that, again, is where I would recommend that you allow them access or unlock doors to prevent any further property damage, because they may and they could knock down doors. So that's why I think having that plan in place where you have somebody who can, the first point of contact is immediately getting a hold of somebody in the company who can then work with ICE agents. If they've got a judicial warrant, we're happy to cooperate. We will not obstruct this, but here's our request. Please put on PPE, or please, this room is a controlled environment and entrance in this could compromise products. So how can we work that out? Hopefully there is that moment of time that you can do that. There may not be.
So you can't require them if they say, no, we're not going to gown up. They can just go in and compromise your whole sterility area.
They could, yes.
Wow. Okay. All right. Steph wanted to know, do you know if there's an uptick of Utah companies being visited by ICE agents?
Well, yeah, I think under the Trump administration, the first Trump administration really focused on those I-9 audits and subpoenas, which were being served. You have, like I said, you have 30 days to respond, a much more controlled environment. Under this second administration, there has been an uptick in companies being searched, and the focus of the administration has been on those individuals, searching and arresting those individuals with criminal backgrounds or reentry violations. And that really was the focus that we have seen for the first 6 months. As the administration goes on, I would imagine that we'll see more generalized searches that aren't really focused on those two priorities. But that's only a guess, but the administration has says that their priority is to focus on the criminal behavior or the violation of reentry orders, those individuals who have outstanding warrants, those individuals who violated reentry orders, but that may likely broaden in scope, and I would expect that it would. Calvin, you're muted.
Sorry about that. Recently, there's a lot of immigrants who are here that are working in our facilities that came under prior guidelines. The parole, I think parole was the term used for those who were here on requesting asylum or things of that nature, if I've got that correct. And the Supreme Court recently ruled that those people's parole could be revoked, even though they had legitimate work documentation. Does that mean that our companies who have employees who are in that situation have to immediately terminate those employees because they would no longer qualify on an I-9 or under E-Verify or something like that?
Yes, I mean, and I would recommend using E-Verify for those individuals, given some of the changes in immigration law, and that will certainly help in that process, especially.
But how would companies know if they have employees that are subject to that, who've had their parole revoked?
Current employees?
Yes.
I don't think they would. I don't think that they would, and you have to be very careful, because then we get into that tension with discrimination. You can't ask somebody if they're a U.S. citizen. You can't ask that during the interviewing process or even the I-9 process. You can ask them if they're legally allowed to work in the United States, but you can't ask them if they're a citizen. That's considered discriminatory. So I think, the dealing with current employees, you start to run afoul of Title VII race, color, national origin discrimination if you were to go through and try and audit your employees at that point.
So if they had employees then, and they had legitimately validated them when they were working that they could legally work, then there was a change, like has happened with this parole situation, and they are now no longer legal, does an employer have an obligation to go back and re-verify everyone, or can they just go along and then if ICE shows up and they find out they've got people who are working that are illegal, are they shielded from liability because they had legal work status at the time they were hired?
That is a great question. I think at the time that they were hired, if they had legal status, it's unlikely that the employer would be held liable for that because the law has changed.
Okay. All right, we've got 3 minutes left. Anybody have another question? Stephanie, we'll get to your last one here. it is our intent to, with Kathleen's permission, to share some of this information with our members. But we will talk to Kathleen and see if this is available to be shared.
Yes. Happy to share it and happy to answer any additional questions that you may have. And, you know, I guess the one final remark that I would make is that this is an ever-evolving situation. Obviously, there are some things that are not going to change it. Well, I say obviously, but you never know. But with regard to search and seizure and Fourth Amendment rights, that remains constant. Those are constitutional rights. But the priorities of the administration, the process of the administration, whether additional just workplace searches will take place as opposed to individual arrest warrants, all of that will continue to evolve as time goes by. So again, I would recommend staying as abreast as possible of these changes, but then also, it's important that employers know what their rights are.
Great. Okay, well, with that, I think that brings us to the conclusion of our presentation. We want to thank Kathleen. Very, very informative. We very much appreciate it. I'm sure there are many others who will benefit from this, and we'll be happy to share this as we are permitted to do so. But thank you, everyone, for joining us today. And if you need to get in touch with Kathleen, you can contact her directly, or we're happy to direct you to that connection as well. So thanks for joining us. Have a great day.
Thank you.